My physiotherapy appointment ran short that Tuesday afternoon, and I found myself with an unexpected hour in downtown Hamilton. I decided to swing by Lakeview Hardware Supply on Barton Street, just to check the mail and say hello to the afternoon crew. Nothing unusual. Just an old man who missed his own company. But when I turned into the rear parking lot off Sherman Avenue, my foot came off the accelerator without me telling it to. There, backed into the loading bay beside my old Silverado, sat a charcoal gray Ram 1500 with a Whistler ski resort sticker on the rear window, my son-in-law's truck, the one that was supposed to be parked at a chalet in British Columbia for the entire week. I sat behind the wheel and stared at it. My son-in-law had shown me the booking confirmation himself, 3 days earlier at Sunday dinner. He'd pulled it up on his phone. Whistler Blackcomb, 7 nights. He and my daughter were treating themselves for their anniversary, and my daughter had asked my younger son to look in on me while they were away. She'd even called me from what she said was Vancouver Airport on Sunday evening. So why was his truck here? 68 years of living will teach you that things which cannot be explained usually carry explanations you don't want to hear. Margaret would have told me to find a logical reason. She would have squeezed my hand and said, "There's always a simple answer, Frank." But Margaret wasn't here anymore. She'd been gone 14 months, and the silence she left behind had made me sharper in some ways and more fragile in others. I sat in that parking lot and felt both at once. I should have driven away. I almost did. Instead, I used my key card at the side entrance, the one my son-in-law had insisted I keep after I handed him the day-to-day operations following Margaret's diagnosis. The hallway smelled the same as it had for 31 years. Industrial cleaner and sawdust and the faint ghost of coffee from the staff room. The overhead lights hummed. The carpet runner, the same burgundy one we'd put down in 2009, muffled my footsteps. That's when I heard voices through the glass partition of the boardroom. I stopped just outside the door. The blinds were half drawn. I could see shapes. My son-in-law stood at the head of the table. My daughter sat across from him, her back straight in a way I recognized, the way she held herself when she was certain she was right about something. And beside her sat a man I hadn't expected. Raymond Cook, our family solicitor for 16 years. The man who had drafted Margaret's estate documents, who had sat with us in the worst weeks of her illness, who had attended her funeral in Ancaster and shaken my hand at the reception. I stood very still. "The application goes to the Ontario Superior Court," Raymond said. His voice was professional and flat. "We cite the Substitute Decisions Act. Once the capacity assessment is complete, we file for guardianship of property. It's straightforward when there's a paper trail." My son-in-law's voice. "What if he pushes back? He won't know enough to push back until it's filed. And by the time he understands what's happening, we'll have the interim order. His accounts, the business, the Ancaster property, all under your management, while the application proceeds." A pause. "Raymond, you're certain the assessor will find what we need?" Raymond again. "I've used Dr. Fenwick before. He's thorough." My daughter's voice was quieter. "What about Thomas?" "Your brother is in Calgary," my son-in-law said. "By the time he hears anything, it'll be done." I stepped back from the door. The wall behind me felt necessary. I put my hand flat against it and breathed. The hallway smelled like sawdust and 31 years of my own life, and I stood in it, unable to feel my legs. This wasn't a family conversation about concern. This wasn't love worrying about an old man who lived alone. This was a schedule, a procedure. They had a solicitor, an assessor, a timeline, and a plan to take everything Margaret and I had spent our lives building. I walked back to the side entrance on feet I couldn't feel. The November air outside was raw, that particular Hamilton cold that comes off the escarpment, and I sat in my Silverado with the engine off until my hands stopped shaking enough to drive. I didn't go home. I drove west on Barton, then north on Highway 6, then nowhere in particular for 40 minutes, watching the Lake Ontario sky go gray ahead of me. By the time I pulled into my driveway in Ancaster, it was dark. I went to my desk, the one Margaret had bought me when we moved into this house in 1998, and I made 2 calls. The first was to the Land Registry office. I asked about the process for requesting copies of all property filings related to Lakeview Hardware Supply Limited and the associated numbered company we use for the Barton Street property. The woman on the phone told me I could come in the following morning. The second call went to a number my former business partner, Derek Haynes, had given me 3 years ago over coffee. He'd used the man during a dispute with a commercial tenant, described him as careful and discreet. The card was still in my wallet, behind my CAA membership. His name was Paul Kirby. When he answered, his voice was alert and unhurried. I told him I had a situation involving my family and my company. I told him I needed to understand exactly what had been done without my knowledge, and I needed to know who I could trust. He said he could meet me Thursday morning. I did not sleep that night. I lay in the bed Margaret and I had shared for 40 years and looked at the ceiling and tried to understand how long this had been in motion. My son-in-law had joined the company 11 years ago. He'd been competent, reliable, charming in the way that people are when they have decided something about you and are willing to be patient about getting it. Margaret had liked him in the beginning. Toward the end, something had shifted in her. She'd grown quieter when he was in the room. I had assumed it was the illness making her tired. I had assumed too much. Wednesday morning, I drove to the land registry office on Main Street West. The clerk brought me a folder that was thicker than I expected. I spread the documents across the passenger seat of my truck in the parking structure on James Street and read them in the flat light of a November morning. By the third page, my chest was tight. A transfer of beneficial interest in the Barton Street property, dated 8 months ago, into something called Lakeview Family Holdings Incorporated. My signature appeared at the bottom, notarized by Raymond Cook. I had signed no such document. By the time I reached the back of the folder, I had found 11 transfers, commercial property, equipment liens discharged and re-registered, a second mortgage on the Ancaster house I had known nothing about. Based on the assessed values alone, somewhere near $4 million had moved without my knowledge or consent. I met Paul Kirby at a diner on Locke Street South. He was in his mid-50s, compact and unhurried, with the kind of stillness that made you want to tell him everything. I did. He read the documents without speaking for a long time. When he looked up, he said 2 words first. The signatures. He placed his phone on the table and showed me a photograph, a purchase order from Lakeview Hardware Supply, dated 7 months ago. Stationery and office supplies, delivered to the Barton Street address. Included in the itemized list, barely visible at the bottom, was a self-inking signature stamp. The coffee in front of me had gone cold. They can use that on anything, I said. It's more common in family businesses than you'd think, Paul said, especially when there's an assumption of trust. Someone puts 30 pages in front of you at the kitchen table. 28 are routine, 2 are not. Nobody reads every line when it's their own son-in-law handing them the pen. I looked at my hands. I trusted him. I know. He wasn't unkind about it. Mr. McAllister, I need to be honest with you. What I'm looking at isn't careless financial management. This is systematic. They've been working toward this for the better part of a year, and based on what you overheard, they're not finished. The capacity assessment, I said, they'll have someone file a formal application for guardianship of property under the Substitute Decisions Act. Ontario law allows a family member to petition the court. Once a capacity assessor provides a supporting opinion, a judge can appoint a guardian to manage all your financial affairs. Everything. Your accounts, your business interests, your real property. You lose the legal right to make your own decisions. How long do I have? If they file this week, you could be looking at a hearing in 4 to 6 weeks. We need to move first. That evening, the courier arrived with an envelope. Thick cream paper, Raymond Cook's firm name embossed in the upper left corner. I read it at the kitchen table where Margaret and I had eaten breakfast for 26 years. Inside was a letter describing updated estate planning documents we had discussed, including a revised power of attorney granting my son-in-law immediate and comprehensive authority over all financial and medical decisions. A covering note said the documents were time-sensitive and should be signed and returned within 5 business days. I had discussed nothing of the kind with Raymond Cook. My daughter called 20 minutes later. Her voice was warm and easy, the voice she used when she had rehearsed what she wanted to say. Dad, did Raymond's package arrive? He mentioned it might come today. Just opened it. Good. I know legal stuff is tedious, but it really is important to have everything updated, especially now that you're on your own. We thought it would give you peace of mind. I appreciate the thought, I said. I'll want to read everything carefully before I sign anything. A small pause. Not long, but I had spent 68 years listening to the pauses in people's voices. Of course, take your time, but Raymond did say it was fairly routine. After she hung up, I walked through the house, room by room. My desk, the filing cabinet in the study, the drawer in the bedroom where Margaret had kept important documents. Nothing was obviously missing. But a side table in the study was not where it had been that morning, and a hanging file in the cabinet was slightly forward of the others, as though someone had leafed through it and not replaced it precisely. They had been in my house. I checked the lock on the rear door. The deadbolt showed faint scratching near the keyway. Margaret had always wanted to replace that lock. I had always said it was fine. On Thursday, I met Paul and a forensic accountant named Sandra Breck at her office on King Street West. She was methodical in the way that certain people are when they find patterns in disorder beautiful. She spent 2 hours with the documents I had pulled from the land registry, the company financials I had requested from our bank the previous day, and the records Paul had independently obtained. "Mr. McAllister," she said, placing her pen down. "Based on what I can see so far, approximately $4.2 million in assets has been transferred or encumbered without authorization. The Barton Street commercial property, 2 pieces of equipment registered as collateral against a private line of credit, and the beneficial interest in your numbered company." She paused. "There is also a second mortgage on your residential property in Ancaster, $240,000 registered 8 months ago." I looked at the street through her window. A streetcar went by on King Street. "Can we prove I didn't authorize the transfers?" "Some of them, possibly. Others will be harder because your signature does appear. The question is whether you were deceived about what you were signing, or whether the documents were forged entirely using the stamp." She folded her hands. "In Ontario courts, the general assumption is that adults understand documents they sign. We'll need to demonstrate a pattern of deception." The next morning, I telephoned Dr. Helen Park's office in Dundas. Paul had recommended her specifically because she had no connection to any member of my family, had never treated me before, and could not be reached through my son-in-law's network. Her receptionist booked me in for Monday. That Saturday, my daughter appeared at my door. She had not called ahead. She was dressed the way she dressed when she wanted something, put together and slightly softened, the way her mother used to describe as company ready. She kissed my cheek and came into the hallway without being asked. "I thought I'd come by. I missed you." She looked around the living room. "You've been quiet this week. Are you all right?" "Fine. Just tired." "Dad." She sat down on the sofa, Margaret's sofa. "I know this is hard. It's been hard for all of us since Mom. But we're worried about you, living here alone in this big house, trying to keep track of everything, the business, the properties, the finances. It's a lot. I manage well enough. You forgot the gas bill last month. It went to collection before you noticed." She paused. "And when Raymond brought those papers for you to sign last spring, you signed them on the porch and forgot about them by the next morning." I looked at her. She held my gaze steadily. "You're right that I signed things," I said carefully. "I trusted that what was put in front of me was what I was told it was." Something flickered behind her eyes. "Too quick to read. Raymond only has your best interests at heart. He's known this family for 16 years. I'd like to speak with him directly before I sign anything further," I said. "I'll call his office on Monday." She stayed another half hour. She asked about my appetite, whether I was sleeping, whether I'd been to see Dr. Mehta recently. All reasonable questions. All questions that could be used to document concern. After she left, I sat in Margaret's chair and thought about how long she had been gathering material. Sunday dinner had been Margaret's idea. Start of the year our daughter was born. Roast beef and Yorkshire pudding, her mother's recipe. After Margaret died, I kept it going. It felt like the one ritual that still held the shape of our family. That Sunday, my son-in-law arrived first. He shook my hand and asked how I was feeling with the particular directness of someone who needs the answer to be a certain thing. My daughter came 20 minutes later. Thomas called from Calgary because he couldn't make the drive, his voice warm and ordinary. Over dinner, my son-in-law cleared his throat. "Dad, there's something we need to talk about." My daughter reached across the table and put her hand over mine. "We love you. Everything we're about to say comes from that." "We're worried," my son-in-law said. "You're alone in this house. The business is complex. After everything with Margaret, it's been too much for one person. I'm managing fine. Dad, you signed documents last spring that you couldn't remember the following week. You left the gas account unpaid for 60 days. Last month you told me you'd called the furnace company, but when I checked, you hadn't." He placed a folder on the table. "Raymond's documents, the power of attorney, and the revised will. We've talked to Raymond. These are sensible precautions. They protect you. They transfer authority over everything I own to you," I said. "That's not protection. That's control." The silence that followed had a temperature. "That," my son-in-law said, his voice going very even, "is exactly the kind of paranoid interpretation that worries us. Is it paranoid to want to understand what I'm signing before I sign it? It's paranoid to sit across from your own family and believe they're working against you. My daughter said nothing. She was looking at the tablecloth. I had known her for 39 years. I knew when she was looking away because she agreed, and when she was looking away because she couldn't look up. I said I would speak with Raymond directly. My son-in-law stood up sharply, said something about trying to help an old man who didn't want to be helped, and the dinner ended 40 minutes earlier than usual. That night, Paul called. Mr. McAllister, they filed this afternoon, application for guardianship of property. Ontario Superior Court of Justice, Hamilton. The hearing is set for December 9th. I wrote the date on the wall calendar. Margaret's handwriting was still on it from last winter. Garden club, dental appointments, Thomas's birthday, December 9th, 3.5 weeks. Monday morning, I drove to Dr. Helen Park's office in Dundas. She was direct about the terms of the evaluation before she began. Mr. McAllister, I'm not here to tell you what you want to hear. If I find impairment, I'll document it accurately. If I find competence, I'll document that. For 2.5 hours, she assessed me. Memory tasks, pattern recognition, orientation questions, executive function tests, backwards counting from 100 by sevens. She asked me to describe complex situations and reason through them. When she finished, she folded her notes. Your cognitive function is intact. Your memory is appropriate for your age and your recent grief. I find no evidence of dementia or significant impairment. She paused. However, I want you to understand that capacity assessment in Ontario can be contested. If your family has engaged Dr. Fenwick, as you described, the court will have 2 competing expert opinions. Judge's discretion will matter. Tuesday, I met a lawyer named Claire Vosberg at her office on Main Street East. She practiced elder law and had been recommended by the Hamilton Community Legal Clinic. She was direct and slightly terse, and Paul had told me those were her best qualities. They've filed for guardianship of property, not guardianship of the person, she said, reviewing the application Paul had obtained. That means they're after the assets, not medical decision-making. The court needs to be satisfied on 2 points, that you lack capacity to manage property, and that appointing a guardian is in your best interests. She looked up. We're going to argue both are wrong, and we're going to put your son-in-law's financial conduct in front of the judge at the same time. Will it get ugly? You'll be contesting your own family in open court. Yes. Thursday, Paul and I drove to a branch of RBC on Upper James Street, one I'd never used. We moved the documents from my home filing cabinet to a safe deposit box, paper records of the original property titles, my original company and corporation documents, the correspondence from Raymond, and the forensic accountant's preliminary report. If they have access to your regular accounts, Paul said, and I believe they do, this is your insurance. The second week moved faster. Sandra Breck completed her report. $4,260,000 in assets transferred or encumbered. The Barton Street property sold to a numbered company registered in Alberta for below market value. Equipment liens, the second mortgage on my house, all bearing my signature via the stamp, notarized by Raymond Cook. Thursday of the second week, my son Thomas called from Calgary. Dad, what's happening? I got a call from a lawyer, Claire Vosberg. She's representing me. Representing you in what? What's going on? I told him. All of it. The overheard conversation, the documents, the stamp, the application, the hearing. I told him about the Thursday at the land registry office, and the Saturday my daughter came to the house, and the Sunday dinner where his brother-in-law had called me paranoid for asking questions about my own will. The silence on the line was long. I'm booking a flight, Thomas said. I don't want you to... Dad, I'm booking a flight. He arrived Saturday evening, direct from Calgary to Pearson, and drove down the QEW to Ancaster in a rental car. He was at my door before 10. He hugged me in the hallway the way he had not hugged me since Margaret's funeral, the way men hug when they cannot say the right words. We sat at the kitchen table and went through everything. He read Sandra's report without speaking. He read the capacity assessment application. He read the power of attorney my son-in-law had submitted to the court as evidence of my agreement to the arrangement, a document with my signature on it, notarized by Raymond Cook, dated 11 months ago. Dad, Thomas said quietly, I think I need to show you something. He opened his laptop. He pulled up a series of emails. They had been forwarded to him the previous month from an address I didn't recognize. I got these a month ago, he said. I didn't understand what I was looking at. I almost deleted them, but something made me save them. The emails were between his sister and my son-in-law, going back 18 months. I read them slowly. They were meticulous. They described the plan in stages. The stamp, purchased through the company account and kept in my son-in-law's desk. The documents to be mixed with legitimate paperwork at family events. The capacity narrative, built gradually through small stories, forgetful moments, checkbook errors, missed calls. Raymond Cook's role, Dr. Fenwick's prior involvement in a similar case. And then, near the bottom of the chain, a message from my son-in-law to Raymond Cook, dated 22 months ago. Margaret noticed something at Easter dinner. She's been asking questions. We need to move up the timeline. I sat at my kitchen table and read that sentence 3 times. Margaret had known. She had known or suspected, and she had said nothing to me. I thought about her in those last months, how quiet she had become when my son-in-law was in the room, how she had asked me once, almost idly, whether Raymond had ever given me cause for concern. I had said no. She had nodded and let the subject go. She had been dying. The cancer had moved faster in those final 4 months than anyone had predicted. She had known she was running out of time, and she had chosen, for reasons I was only beginning to understand, not to put the weight of an unproven suspicion on my shoulders in her final weeks. Thomas and I sat at the table for a long time without talking. December 9th, the Hamilton Courthouse on Main Street West. Claire Vosberg met me on the steps at 8:45 in a wool coat, carrying a leather briefcase. Thomas stood beside me. The sky was flat white, the kind of Hamilton winter sky that promises nothing. My son-in-law and Raymond Cook were already in the courtroom on the 2nd floor. My daughter sat behind them in the gallery. She looked at me when I entered, and something in her expression broke slightly before she steadied it. All rise. The Honorable Justice Patricia Lamb was in her early 60s, precise and unhurried. She reviewed the application documents and looked up. This is a guardianship of property application under Section 22 of the Substitute Decisions Act, filed by Mr. David Calloway on behalf of his father-in-law, Francis McAllister. She paused. I see the respondent is present and represented by counsel. She looked at Raymond. Mr. Cook, you weren't anticipating a contested hearing. Raymond stood. Your Honor, given the documented evidence of Mr. McAllister's cognitive difficulties, we did not expect him to mount a formal response. Yet here he is. Justice Lamb looked at me with an expression I couldn't entirely read. Mr. McAllister, do you understand the nature of this proceeding? Claire rose. Your Honor, if I may, I'd like to hear from Mr. McAllister directly. I stood. Yes, Your Honor. My son-in-law is asking this court to declare me incapable of managing my own property. I dispute that completely, and I intend to show this court why this application was filed. Justice Lamb studied me for a moment. Very well. Mr. Cook, proceed. Raymond presented his case with the confidence of someone who had done this before. He described a man diminished by grief, by age, by the ordinary erosions of a life lived long. He cited the checkbook error, the missed furnace appointment, the documents signed and forgotten. He submitted an affidavit from Dr. Fenwick, a psychiatrist who had, in Raymond's words, conducted a thorough review of Mr. McAllister's recent conduct and found reason for serious concern. He called my son-in-law to the stand. My son-in-law looked at Justice Lamb and not at me. What's your relationship to Mr. McAllister? He's my father-in-law. I've run his company for 11 years. I love him. Describe your concerns. He was practiced. He described the checkbook error. He described a Sunday dinner where I had forgotten a conversation we'd apparently had the previous week. He described standing in my office doorway and watching me read the same paragraph of a document 3 times before setting it down. Claire stood for cross-examination. Mr. Calloway, isn't it possible your father-in-law trusts you and assumes documents you present to him are what you represent them to be? I suppose. The checkbook error. Could that not happen to anyone regardless of cognitive status? It could. Is it possible that your father-in-law has simply been grieving his wife of 41 years? Silence. Yes, he said quietly. I suppose it is. Claire called Dr. Park by video conference. Dr. Park was composed and direct. She described her evaluation, the tests, the results, her conclusion. Mr. McAllister demonstrates intact cognitive function, intact memory appropriate for his age and recent bereavement, and no evidence of dementia or incapacity. In my clinical opinion, he is entirely capable of managing his own property. Then Sandra Breck took the stand. Her spreadsheets went up on the courtroom display, clean and annotated. She was not a dramatic person, and she did not try to be. She explained numbers. Your Honor, between 14 and 22 months ago, approximately $4,260,000 in assets belonging to Francis McAllister and Lakeview Hardware Supply Limited were transferred or encumbered without clear authorization. These transactions utilized a self-inking signature stamp, purchased through the company account and traceable to the respondent's premises. The stamp was used on 11 registered documents. Justice Lamb leaned forward. Mr. Cook, were you involved in the preparation of these documents? Raymond stood. His composure had thinned. I acted on instructions I believed to be Mr. McAllister's. Instructions you verified personally? A pause. Some were provided by Mr. Calloway on Mr. McAllister's behalf. Justice Lamb's expression did not change, but it did not need to. Claire rose. Your Honor, may I call a witness? Thomas took the stand. He presented the emails. He described receiving them from an anonymous address, saving them, and not understanding their significance until his father called him from Hamilton. He described Margaret, his mother, who had been meticulous about family records, who had spent 31 years as the quiet administrator of every important thing in this family. The courtroom was very still. Then Claire said, Your Honor, I have one further matter. A woman entered from the rear of the courtroom. She was perhaps 70, carrying a leather portfolio. I did not know her. She walked to the front of the room and spoke to the bench. Your Honor, my name is Anne Sheridan. I'm a notary with an office in Ancaster. 14 months ago, Mrs. Margaret McAllister came to my office and left with me a sealed document. She instructed me that the document was to remain sealed and was only to be produced in the event that Francis McAllister's legal competence was formally challenged in court. She placed the portfolio on the bench. I received a call from Mr. McAllister's solicitor yesterday afternoon. Justice Lamb examined the exterior of the sealed envelope for a moment. She looked at me. Mr. McAllister, are you familiar with this document? No, Your Honor, I said. I am not. The seal was broken. Anne Sheridan handed the document to Claire, who handed it to me. Margaret's handwriting, the particular slant she gave to capital letters. The way she wrote my name with a small extra loop, the way she always had on birthday cards and notes left on the kitchen counter. I read it aloud because Claire asked me to. My voice held for most of it. My dearest Frank, if you're reading this in a courtroom, then what I feared has come to pass, and I'm sorry I wasn't there to help you face it. 8 months before she died, at Easter dinner, my son-in-law had said something that reached her in a way she couldn't explain. He had used the word when about something that should have been if. She had watched him afterward the way she watched things that troubled her, quietly, making no noise. She had found fragments, an email on a shared family account she still had access to, a document on the printer in the den that my son-in-law had not realized she was nearby to see. Nothing conclusive, she wrote. Nothing she could bring to me without risking him going deeper underground if the warning reached him. She had been dying faster than predicted. She had a choice. Spend her remaining weeks putting an unproven accusation into the air, or trust that the evidence would surface if she planted the right seed. She had gone to Thomas. She had told him what she suspected, given him copies of what she had found, asked him to watch, and asked him, if anything ever came to court, to be there. I'm sorry I didn't tell you, she had written. I was afraid of being wrong. I was afraid of what it would do to our daughter if I accused her husband without proof. And I was dying, Frank, and I didn't want our last months to be consumed by this. I wanted what time we had left to be ours. But I know you. I know you're sitting in that courtroom, and you've already gathered your evidence, and you've already fought back the way you fight everything, steadily and without fuss. I know because I watched you build a company for 30 years on nothing but stubbornness and honesty. I love you. I am still, from wherever I am, trying to take care of you. Yours always, Margaret. I looked up. Thomas was crying. My daughter had her face in her hands. Justice Lamb was quiet for a moment that seemed longer than it was. When she spoke, her voice was measured. I have practiced law in Ontario for 32 years. I've seen guardianship applications brought out of genuine care, and I've seen them brought out of interests that have nothing to do with care. She looked at the documents before her. Mr. McAllister has not demonstrated incapacity. Mr. McAllister has demonstrated precisely the kind of careful, thorough, and legally competent response that this court looks for in a fully capable adult. She paused. The application for guardianship of property is dismissed. Mr. McAllister is confirmed as fully capable of managing his own affairs. I am ordering the preservation of all documents related to Lakeview Hardware Supply Limited and Lakeview Family Holdings Incorporated, pending investigation by the appropriate authorities. I am referring the matter of the registered signature stamp and the property transfers to the Ontario Provincial Police Financial Crimes Unit and, in light of Mr. Cook's involvement as a solicitor, to the Law Society of Ontario. The gavel came down. Claire put her hand on my shoulder. Thomas was beside me before I stood up. My daughter crossed the courtroom floor and stopped in front of me. She looked the way she had looked the morning after Margaret died, wrung out and small. She said nothing for a moment. Then, "I thought we were protecting you. I thought—" She stopped. "He told me you were getting worse. He showed me things. He told me it was what Mom would have wanted." "Your mother left a letter," I said. "You heard what it said." She broke then, not loudly, the way our family breaks, quietly and with great effort to hold it together. I held her in the aisle of the courtroom while she wept. Across the room, my son-in-law sat with his lawyer, not looking at any of us. 6 weeks later, the OPP Financial Crimes Unit called. They had confirmed the stamp, the forged documents, the transfer structure, and Raymond Cook's participation in notarizing documents he knew to be fraudulent. My son-in-law was charged under Sections 380 and 403 of the Criminal Code of Canada, fraud over $5,000 and identity fraud. Raymond Cook was separately charged and referred to the Law Society. His license was suspended within 10 days. 8 weeks after the hearing, Sandra delivered the recovery numbers. We had recovered $3,400,000 of the $4,260,000 transferred. $860,000 remained in accounts in my son-in-law's name that had been frozen pending the criminal proceeding. The shortfall was roughly $200,000, moved through a series of personal expenditures that were difficult to claw back. 92% recovered, better than Claire had estimated. My son-in-law's case took 4 months to resolve. He took a plea agreement, 12 months in a federal correctional facility in Ontario, 3 years of supervised probation, full restitution from frozen assets, a lifetime prohibition from serving as an officer or director of any corporation. His lawyer had argued for a conditional sentence. The Crown had asked for 2 years. 12 months was the compromise. I did not attend the sentencing. Thomas came down from Calgary for it. He texted me when it was done. My daughter came to Sunday dinner the following week, just her, without the children, and we sat at the kitchen table where her mother had made Yorkshire pudding for 30 years and ate roast beef and said very little that mattered and a great deal that did. She had known something was wrong with the plan. She had told herself it was care. She had told herself her father was struggling because it was easier than believing her husband was lying to her. "I should have asked you directly," she said. "I should have come to you. Instead, I let him tell me the story, and I believed it." "He was careful about what he showed you," I said, "and you wanted to believe your husband over your father. That's not unforgivable." She looked up. "Are you going to?" I didn't answer that night. The question needed more time than one dinner. Spring came to Ancaster slowly, the way it does along the escarpment. Snowdrops first, and then forsythia, and then the long, cautious opening of the maple trees in the yard Margaret had planted and tended for 26 years. I sold the commercial property on Barton Street to a family that had been renting space from us for 9 years and wanted to expand. Fair price. Reasonable terms. They had been good tenants, and good tenants deserve a solid foundation. I restructured the company. Smaller, cleaner, with a young general manager named Patricia who had worked her way up from the floor and understood that transparency was not a courtesy, it was a condition of employment. One Saturday in April, I drove to the cemetery on Wilson Street. Margaret's stone is plain, the way she wanted it. I sat on the bench nearby and told her everything she already knew. "You didn't tell me because you wanted our last months to be ours," I said to the granite, and they were. And I'm still angry about the months I lost and the documents I signed and the way I sat in that parking lot unable to feel my legs. And I'm grateful in a way I don't have words for, because you were careful and you were quiet, and you were always watching out for us. Thomas came to visit in May. We drove up to Dundas for dinner, the Italian place on King Street that Margaret had always liked. He told me about his life in Calgary, his daughter who was finishing her 2nd year at the University of Calgary, the promotion he'd accepted at his firm. At the end of dinner, he said, "Dad, are you going to be all right?" I thought about the question honestly, the way I had started to think about more things honestly, without the shorthand that men of a certain generation used to avoid answering. "I'm going to be exactly what I am," I said. 68 years old and no one's fool. He laughed. It sounded like his mother's laugh. Driving home down the mountain, the Hamilton lights spread below me along the lake shore. I thought about that Thursday afternoon in the parking lot. The charcoal gray truck in the loading bay. My foot coming off the accelerator without being told to. 68 years of living telling me something I didn't want to know. Margaret used to say that the things we notice without trying to notice them are the most important things we ever see. She was right. She was usually right. I keep Sunday dinner going. My daughter comes, and sometimes Thomas drives in from Calgary, and my grandchildren sit at the table where their grandmother made Yorkshire pudding and talk about things that matter very little and everything at once. I listen to them, the way you listen when you have learned the hard way, that the people in front of you are the only things worth protecting. Age is not confusion. Age is not weakness. Age is not a balance sheet that someone else gets to manage because they have decided you cannot. Age is every Thursday afternoon you have ever driven home knowing something was wrong and choosing to do something about it instead of nothing. Trust carefully, verify honestly. And if someone you love is watching out for you from a place you cannot reach, the least you can do is be worth watching over.